Friends, welcome to our today's show. We are going to start a new concept again today. This is about the concept of memorandum of association. We'll try to understand what is that document. When we are learning that previous chapter about incorporation of company, at that time we have already understood that in order to incorporate a company, we need various documents. And also we have understood we have to draft a particular document which is called as MOA. And you know, MOA stands for? MOA is what?
Memorandum of Association.
Memorandum of Association. Okay, have you remembered? We had already discussed that that document is required. When you want to start a company, we have to prepare a document called as MOA. Other documents will also be prepared. In fact, one main document, this is one of the major documents that is required to form a company. Right? One is MOA. Another kind of document, another important document is AOA. Can anyone tell me what is AOA?
Article of Association.
Articles of Association. Both are very important documents. When we plan to incorporate a company, we have to prepare these two documents. Let us learn what is that, how we'll be able to prepare that thing. For learning that thing, let me share the screen with you right now. Okay. And the picture you are seeing here, this is just a picture of a e-memorandum form. We'll be learning all these things. Yeah. First, friends, we have already launched various provisions regarding incorporation of company. If you look at this is the chart of the section-wise arrangement. Incorporation part we have already learned. We know this section 3, section 3A, 7, 8, 9, etc. we have already covered. So the next area relating to incorporation is about MOA and AOA. As you can see, MOA is dealt in section 4, AOA is section 5, AOA will be learning separately. Then Act is superior to Memorandum of Association or Articles of Association. This concept is discussed in section 6. That means section 6 says that if there is some inconsistency between the memorandum or article or act itself, then which is superior? Act is superior. Okay, in case there is some discrepancy, there is some inconsistency between these two, then act is superior. Then section 13 talks about changes in Memorandum of Association. Section 14 is about changes in AOA. And these changes to be noted, we'll see how changes will be noted. That will be discussed in section 15. And section 17 talks about copies of MOA or AOA should be provided to members. Okay, so these are various sections. So most important section right now is section 4. Okay, so we start from that. Section 4 we need to understand to know what is Memorandum of Association. So let me take you to, before showing you the slides, let me just take you to the website, Ministry website. Okay. Oh, sorry. You are watching mca.gov.in. Okay, are you able to look at this? Are you able to see it? Are you seeing MCA website?
Yes, sir. Yes, sir.
Yes, sir.
Yeah, what I'm doing, I'm now opening the act for you. Right, this acts, this concept is very important for us. So I think many of you might be right now familiar with this website. I have already explained you how this act is divided into various sections, chapters. You can see it here. Okay. And now you see, after chapters are over, there are these schedules are there, is it not? You see, schedule 1, schedule 2, schedule. Okay, are you seeing it? Now, schedule 1, and this is schedule 1, table A. Table A, can you read it? Memorandum of Association and Articles of Association, table A. Then Memorandum and Articles of Association, table B. Then you see another table, table C, table D. Are you seeing all these things?
Yes, sir.
Okay.
Yes, sir.
Memorandum article. Okay. Table D, table E, table F, table G, table H. So these are friends, in fact, the formats of memorandum. Okay. Table up to table J. You can see these are the various formats of memorandum. We'll be seeing later on. We'll see how to see it, how to understand this. A particular company may follow a particular format. There's various standard formats are there. We can see that. Now, first of all, we need to know this thing, memorandum, the section 4 I told you. So let us look at that. That comes under this incorporation chapter. Okay, now you see. Can you see? If I click here, I am finding these are the sections. Can you see it? Section 4 talks about what? Can you read it?
Memorandum.
Memorandum. So easily one can directly read it here. Okay. So I'll be showing you the provisions with the help of slides. But before that, I just wanted to show you how acts looks like with regard to memorandum. You see, it talks about memorandum of company shall state, that means certain things are there which needs to be stated in the memorandum. Are you seeing it? Okay, section 4, subsection 1, then subsection 2 talks about the name stated in the memorandum shall not. That means certain restrictions are there. You should not give that kind of, you should not use those kind of words as names of the company. So section 2 talks about that. Okay. Okay. So there is some other thing in section 3. So, sorry, subsection 4, subsection 3, subsection 4. Okay, you can have a look at this. Subsection 5, 6, 7. Subsequent some amendments are there. This entire memorandum is dealt with here. Understood? Now I will take you to slides. Let me show you the slides now. So now our plan is to learn section 4 and related sections also. We'll be learning. Maybe section 6 will be learning, section 13 will be learning, then section 15, then section 17. All these things we are supposed to learn. To start with, let us see first of all. Let us understand the definition of memorandum first. You see, the definition of memorandum is provided section 2, clause 56. I am not showing you there. You can directly find it in the act itself. You know, section 2 talks about all definition, and clause number 56 defines memorandum. I request some of you, please read this provision. This is exactly what is written in the memorandum. Please, any one of you may please read the definition. Please read it out.
Memorandum means the memorandum of association of a company as originally framed or as altered from time to time in pursuance of any provision, company law, or of this act.
Thank you. So this explains us one concept, that memorandum can be originally framed. That means when we incorporated a company, that means when we formed a company, at that time, definitely we have submitted one memorandum. But that doesn't mean that that is the final memorandum. Memorandum also keeps on changing. From time to time, we bring amendments to the memorandum. So when we talk about memorandum, it might be the original memorandum or the memorandum which has been subsequently altered. That is also memorandum. Okay. That is why this definition talks something like this. It talks about, if you read once again, it means the memorandum of association of the company as originally framed. Originally framed means when company was incorporated, memorandum was framed, or as altered from time to time. If a memorandum is altered subsequently, that means when we talk memorandum, it means altered memorandum. Okay, how alteration can happen? Alteration can take place in pursuance of any previous company law or in this act. Okay. Okay, can be altered from time to time, right? Originally, it can be prepared in pursuance to previous, in pursuance to company's law, maybe existing law, or maybe in accordance with the old law. That means there might be some memorandum of association of a memorandum of association of a company which is incorporated in earlier law. That memorandum might be different. That may look totally different. Is it not? Would you like to see some old memorandums?
Yes, sir.
Would you like to see? Okay, let me try to show you. Just give me 1 minute. Let me try to show you. Just give me 1 second. Let me find out some very old memorandum if it is possible. Give me just 1 second. Okay, I'll be later on. I'll be showing you some other memorandum. So this memorandum which I'm going to show you, not that old, but still you can relatively old, you can say. Okay, I will be able to show you one old report, old memorandum. Maybe some other day I can show you much more older one. But right now, let us see. Yeah, here is a memorandum I'm showing you of a particular company. Are you able to see it? This is under which act? Can you read it? Companies Act 1956. Right now, the memorandum, let us say right now, is currently you will be incorporating a company. So that will be the Memorandum of Association under Companies Act 2013. But this is under Companies Act 1956. Did you understand? But you see the contents are more or less same. But today's we see memorandum, e-memorandum, electronic memorandum, which are prepared, which are submitted online. But this memorandum you see, Companies Act 1956. This is called as the name clause. Are you seeing it? Name of the company will be so and so. Then next is registered office clause. Next clause you see objects. Are you watching it?
Yes, sir.
So 3 clauses are name clause, registered office clause, objects. This object clause has got 2 parts. One is the main object. Second is objects incidental or ancillary to the attainment of main objects. So this is object clause, main object. These are the incidental or ancillary objects you see. So 4 clauses you know. Name clause, registered office clause, object clause, these 3 clauses I told you so far. The next, you see so many objects are there. Company can do all these things. Company cannot do anything beyond this scope. This object clause, in fact, specifies the scope of the company, what the company can do. And then one more thing also, other objects are also there. Then 5th part is the liability clause. Okay, it clearly says the liability of the members are what? Limited. Liabilities clause. Then the 5th clause is the capital clause. It says the capital of the company is this one. Okay, so how many clauses I told you? Name clause,
3.
registered office clause, object clause, then liability clause, then capital clause. Okay, and finally,
5.
yeah, 5 clauses. This finally, an object clause has got 2 parts: main object and objects which are incidental or ancillary for attainment of the objects. Okay. Now you see, today's in modern days, we sign memorandum electronically, we attach digital signature. But in those days, under Companies Act 1956, you see, physically, the subscribers of memorandum were signing. Yes, you see, these are the subscribers who are signing it. Okay. And that also, again, to be declaration has to be given a professional. He has to also sign manually. Okay, both the signs you see manually. Are you saying? But today, what we do, we attach digital signatures. Okay, here you see manual signatures are there. The professional who is involved in the incorporation of the company, he has also signed manually. And all the promoters who are the subscribers of memorandum, they have also signed manually. Okay, understood?
Yes, sir.
Got some idea about this new memorandum? At the same time, let me show you an old, this is the old memorandum. Let me show you some old, new memorandum also. Okay, modern memorandum. Let us see it. Just give me one more second. Yeah. Are you seeing this memorandum? This is also one more memorandum. Okay, this is online. This has been submitted. You see, pre-fill buttons are there. Data can be pre-filled. This is the e-memorandum was. Here also you can see the name clause. Are you seeing it?
Yes, sir.
Then you see registered office clause or situation clause. It talks about this. Then you see object clause. Okay, this is main object. This is the object which are incidental to the main object. Are you understanding it? You see so many objects are there. Okay. Now next clause you see liability clause. Can you see it here? Clause 4.
Yes, sir.
Then capital clause.
Yes, sir.
Are you saying it here? Capital clause. Then finally same thing. But here you see manual signatures are not there. These are digital signatures. Are you watching it here?
Yes, sir.
Digital signatures are there and the professional was involved. He has also put his digital signature. Okay, this is e-memorandum, electronic memorandum. Okay, I think before seeing the provisions, now you have thoroughly understood or you have now a good idea about how memorandum looks like and what are the contents of memorandum. Can you recall now what are the contents? If somebody asks you what are the contents of memorandum, will you be able to write it? Tell me. Clauses, what are the clauses? First, which clause comes first? Who can tell me? Should I help you?
Name,
Ye-
sir.
ye-
Name clause. Fantastic.
Name clause, sir.
Name clause. Then
Address, sir.
what is the next clause?
Situated
Address.
location, sir.
Situation clause or registered office clause. Okay. Then
Then, sir, objective, sir.
object clause. Object clause, it has got two components. Can you tell me what are these? What are they?
Sir, main objective and
Main object and objects which are incidental or ancillary for attainment of main object. Okay. What is the next clause? Name clause, registered office clause, object clause. The next
liability.
Liability.
liability clause. Okay. It says the liability of members are limited in most of the cases, unless you are incorporating an unlimited company. It's like that. Liability of members are limited. Then next clause,
Sir, capital clause, sir.
capital clause. So very good, fantastic. Now you have understood the concept. Now next friends. Yeah, so definition of memorandum you have already understood. Now, what is articles we'll be learning later on. But at this stage, just have an idea. Means articles of association, which is originally framed or as altered from time to time, or applied in pursuance to any previous company law or this act. Applied means there is a provision. If the company doesn't have an articles of association, then one particular table will be applied. Okay, that's a different thing. When you will be learning AOA, at that time you'll understand what is articles. Now, friends, let us go to this section 3.1, which you had learned earlier at the time of incorporation. We have learned this section earlier also. At that time, we have seen that the section says a company can be formed for lawful purposes by 7 or more persons. Okay, lawful purposes by 7 or more persons, where company is to be formed to be a public company. 2 or more persons, where company is to be formed to be a private company, or 1 person, where company is to be formed by 1 person company, that is to say a private company, by subscribing their names or his name to the memorandum. That means it says to the memorandum and complying with the requirements of this act in respect of registration. Meaning, if I want to form a company, then these many people need to subscribe to the memorandum. Okay, that is important, because unless these many people subscribe to the memorandum, you will not be able to get the company registered. Understood? How subscription happens? You have already seen subscription, how will happen. You have seen the last page of the memorandum. You have seen those people who have promoted the company, they have signed. When they have signed means they have subscribed. Did you understand? You have seen a page like this now. I'll show you. Yeah, this page. This means these people have subscribed to the memorandum. You see, at the top you can find out subscribers detail. These are the people who are signed. Okay, this is their DIN, director's identification number. This is their DSC. This DSC and DIN both are important for incorporation of a company. We have understood that concept earlier. Okay, friends, now you know how this particular document is important. Document is important because without subscribed memorandum, we will not be able to incorporate a company. Okay, and we also know the company formed under subsection 1 can be either limited by shares, limited by guarantee, or unlimited company. And these concepts are also needs to be described or specified in the memorandum, whether share company liabilities are limited, or it is limited by guarantee, or it's an unlimited company. That also should form a part of memorandum of association. Okay. Now, section 4, if you see, section 4 talks about contents of memorandum. It says the memorandum of association shall state. Now, point wise, several items are there. You have already seen it in the website. Also, what should the contents of the memorandum of association? First, you see, it says it should state the what? Can you read it?
Name of the
Name
company.
of the company. That means each memorandum must first of all state the name of the company with the last word, limited or private limited. If it's a private company, then we should use the word limited, or we can use the word private. Okay, but one more thing. Nothing contained in this clause shall apply to a company registered under section 8. That means if the company is registered under section 8, it's not necessary for that company to use the word limited or private limited. You already know that concept. Earlier also, I had shown you incorporation certificate of a section 8 company, where you had seen that the word limited or private limited was not there. Is it not? Even if it was a private limited company, but this word was not there. Have you remembered? You have seen it or not?
Yes, sir.
Yeah.
Sir, section 8 works for promotion of culture, sports,
Yeah.
and all that you
Very
have
good.
talked
Very
about.
good.
They are non-profit organization and all.
Ah.
So that's why they cannot put limit and limited the company.
Okay. So first thing, the memorandum association should state the name. You have understood this condition. Second, it should also state the registered office of the company. State the state in which the registered office of the company is to be situated. That means it should also be stated the state in which the registered office of the company is to be situated. If it is situated in the state of Odisha, you just write state Odisha. You have that also. You have said if it is situated in the state of West Bengal, write West Bengal. If it is from Punjab, write Punjab. Then what next it has to state? So name has to be stated, state of registration has to be stated, then objects for which company is proposed to be incorporated, and any matter considered necessary in furtherance thereof. Let us say object of the company is to do some business. Okay, suppose objective of the company is to do a healthcare business, to run a hospital. That is the objective. But for the furtherance of that objective, many more things are necessary. For example, the company might have to, let us say, run a pharmacy, or company might have to construct a building. So these are certain activities which are necessary for furtherance of the main objective. So these objectives are called as objectives which are incidental or ancillary for attainment of main objective. That also has to be stated. Okay, understood? So
Sir,
here you,
sir,
yeah.
sir, that last two lines, sir, the voice got somewhere some problem. So I didn't. Sir, last two lines, sir, please repeat.
Okay, last 2 points, the B and C. First of all, name of the company has to be stated. Okay, the state of registration has to be stated in the memorandum. Then objects of the company. Okay, objects for which the company is proposed to be incorporated. That means we are talking about the main objects has to be stated. And any other object which is considered necessary for furtherance thereof. That means objects which are incidental or ancillary for attainment of main objects, that also has to be stated. Okay. That means incidental object. Okay. Now you see, suppose name has been stated. Registered state of registration has been stated. Now main object, you see, this is the main object. Okay. This company objective is to carry on the business of seed production, then processing and trading. This is the main object. But for doing that thing, the company might have to purchase equipments, purchase machinery. So this is, you see, this is object matters which are necessary for furtherance of the object. That means for carry out this object, you have to do some more thing. They are stated here. Are you getting me?
Yes, sir. Now it's clear, sir.
Okay, you have understood this, right? Now, again, this particular section says, what next? What other things you have to specify? The liability of the members of the company, whether limited or unlimited. That also has to be stated. In case of a company limited by shares, it has to state that the liability of the members is limited to the amount unpaid, if any, on the shares held by. In case it is limited by guarantee, then it has to be stated that the liability of the members are limited to a particular amount, to the guaranteed amount. That means member has to undertake to contribute to the assets of the company in the events of its being wound off. While the members, when he is a member or within 1 year after he ceases to be the member, okay, that means if the person is a member of a company in the event of winding up, he has to contribute something. He must give an undertaking. If has given some undertaking, he has to contribute that amount. That is called as a guaranteed amount. But even if, let us say, members, he is no more member within, let us say he was earlier member, but within 1 year from the date of winding up, that member is also liable to contribute the guaranteed amount. Okay. So if he is a member, either he is a current member or member with, he was a member within 1 year. Okay. Then also that member is also liable to contribute the guaranteed amount. Okay. So if
Yes,
members has undertaken to contribute some amount in the event of winding up, or to the costs, charges, and expenses of winding up, then members are liable to pay that much only, not beyond that. That's why again members' liability is limited by guarantee. Suppose one member has undertaken that he will pay 5 lakh rupees in the events of winding up. So when the company is getting closed, he can contribute 5 lakh rupees because that is the amount he has guaranteed. Okay, so this is the concept of one company limited by guarantee. Did you understand?
Yes, sir.
Clause 4. Now you see. Here it says, you see, this clause, the liability of the members are limited, and this liability is limited to the amount unpaid, if any, on the shares held by them. This is the line which is included in the e-memorandum. Then 5th clause, as you can see, the company's capital is this much. That is clause 5th. Okay, clause E. In case of a company having share capital, what the memorandum should state? The amount of share capital with which the company is to be registered. Okay, if the company is to be registered for a share of 5 lakh, 10 lakh, 15 lakh, whatever it might be, that has to be stated. And the division thereof into shares of fixed amount and the number of shares which the subscribers to the memorandum agree to subscribe, which shall not be less than 1 share. Okay, that means what you have to state? You see, total share capital in this many rupees. Okay, 4 lakh rupees divided into 40,000 equity shares of 10 each. So this breakup has been, this 4 lakh share has been divided into 40,000 number of equity shares and each share valuing rupees 10. Okay. Did you understand? Yes or no? Are you getting it? Okay. Now, and you see, the subscriber to the memorandum should at least subscribe for 1 share. You cannot subscribe for less than 1. You cannot subscribe, let's say, 0.5 share or 0.75 number of shares. No, that's not possible. Okay, and the number of shares each subscriber to the memorandum intends to take indicated opposite to his name. That means how many shares he wants to take must be indicated in his name. Now you can see. So here is a subscriber. You see name, address, description, occupation. Or this is subscriber's detail. This is the subscriber. Okay, you see how many shares he has undertaken to subscribe? 2,000 shares. Minimum 1 share he has to subscribe. So each subscriber has to say that how many shares he is going to subscribe. Are you getting it?
Yes.
Okay. Okay. And there's one more clause that in case of one person company, that is OPC, the name of the person who, in the event of death of subscriber, shall become the member of the company. This concept we know when we are discussing about OPC. We know OPC means it's a company where there is only one member, but at the time of incorporation of the company, he has to also subscribe another person's name. Okay, who, in the event of death of the subscriber, shall become the member of the company. So that company can run in the event of that one person's death. Okay, this is applicable only in case of OPC. Otherwise, this particular clause is not applicable. Okay, understood?
Yes, sir.
Yeah. Is it clear up to this? Understood various components of memorandum of association?
Yes, sir.
Okay, now you can see name clause, then the situation clause, then object clause, which has got twofold objectives, then your liability clause and capital clause. These are the contents of any memorandum of association you have seen. There are some related provisions also. So all these things you are discussing is this section 4 clause, section 4 subsection 1. Now, if I move to clause 4, section 4, subsection 2, some other relevant things are there. It says the name stated in the memorandum shall not be identical or resemble too nearly to the name of existing company registered under this act or under any other previous company. Okay, that means you have to see that the name should not be too similar with some other existing company. That company might be registered under this act or maybe some earlier law. And also you have to ensure or be such that its use by the company will constitute an offense under any law for the timing in force, or it is undesirable in the opinion of central government. If the name is undesirable in the opinion of central government, that name one should not apply, and it should not such name that it will constitute an offense. Let us say some words, use of certain terms, certain words are prohibited. You are not supposed to use that thing, otherwise that will become an offense. Okay, so that selection of name is an important concept. So how normally one needs to select a name? Let us try to see it practically, how it is possible. Again, let me take you to the let me take you to the MCA website. Just give me 1 second. Yeah, are you able to see MCA website now?
Yes.
Okay. Now you see. We'll see the MCA services. Okay, MCA services, master data I had already shown you how to search the company details. Now you see, just a minute. You see company services. Under company services, if I click, there is some issue right now in the site, but still let me try once again. Company services, you see under company services, check company name. Okay, you can check company name. You can find out whether there is any company the same name or not. Let me try once again. Check company name. Oh, I see. You see this right now. Site is not working. There is some issues. So, but still, let me make one more time. Let me try. Otherwise, I will keep it pending. Maybe next class I will be showing you. Sometimes this happens. Well, it's not working. But I will be showing you, maybe in next session, I will be showing you how to look for the name and how to check it. Yeah, just I will give you some basic idea. Next class, I will practically show you. So if you go to MCA services, this is the screenshot. This is a photo of the screen, but we'll see it on real-time basis. We'll be saying. Now you see MCA services, you can go in MCA services, you can find a link. What is this? Check company name. Okay. Check company name, and then you can type it. You will get a screen like this. If you are planning to apply for a company, you can type your name here. What kind of company, what kind of business it will do. You can add more names also. You can also check that whether that particular name is registered with trademark authorities. That means if somebody is already having trademark of that name, then you cannot use that name. That also you can check here. You can also check here whether a domain name is available. Okay, that also you can check here. So this is the thing, but right now since site is not working, I'm unable to show it, but I'll be showing you definitely next time. Okay, by typing the name, let us say I'm typing the name here as per type of activity, let us say hospital. So I'll be getting a list of similar companies. That means this company already existing. So I cannot form a company with this name. As you can read, you see, as per Hospitality Services Private Limited, as per Hospitals and Realty Private Limited. These two companies were already there. Let us say this company is registered Asper Hospitals Private Limited. This is registered in the state of Odisha. On that memorandum, I was showing 1/7/2013. It is registered. Okay, but it is not too similar. That one is Asper Hospitality was there, which is incorporated in 2011. But subsequently, one more company is also allowed, that is Asper Hospitals and Realty Limited. 2017 is allowed. Okay. Now you can see this is, so like that you can check the name. And here there you have also seen there is a link check trademark. So you can check also trademark, that there is any trademark against that company or not, against that name or not. Okay, you can start with, you can fill up the words, that is Asper class, which class this industry belongs to you. You have to find out first, that is, this is class 45. If you want to know which class, there is a link here. Can you see it? Class details. You can search that hospital industry belongs to which class. Then that class number you can put it here. Okay, then you can find these are the trademarks which are already registered. So you need to have a different trademark. Okay. Similarly, you can also apply for domains. You can check the domain name availability. You see aspire.in, like this, you can search it. Okay, so whether it is available or not, you can find out, you can get a message. Okay, understood. So when registering the company, these are the certain basic things one need to take care of. Okay, first of all, memorandum has to be prepared. That is one thing. But in the memorandum, you have to write name. So you have to be extremely careful while selecting the name. Right, and there is also possibility that you can reserve the name first. First, you can apply for the name, then get it reserved. After that, when you are applying for registration, you can use that name. And that registration, as of now, that name is kept reserved for a period of 30 days. After 30 days, you can again apply for a fresh reservation, or what you can do, that reservation is gone, you can apply for a fresh name. That is also possible. Okay, so this is how memorandum is important. This is how various these are in fact the various contents of the memorandum. That's what we discussed today. There are a few more things relating to memorandum we'll be learning, but not today. We'll be learning it in our next class. Do you have any query up to this? Any doubt you have so far?
No, sir, clear.
Is it clear up to this? Everything is
Sir,
clear.
yes.
Yes, sir. Yes.
Sir, the point D, sir, please discuss point D.
Point D. Achha, which
Point
one?
D.
That point D, perhaps that auxiliary one, perhaps maybe he's saying, if not mistaken.
Which one? Point D you are talking about?
Sir, liability.
Liability clause. That's what I told you. No, the liability clause means the liability of the members are limited. Okay, you see, if you already know, when we are discussing about various types of company, you know there are broadly two types of company, you can say. Right? It can be unlimited company, it can be limited company.
Yes.
One way of classification. If it is limited, it can be limited by shares or it can be limited by guarantee. If it is limited by shares, then it has to be stated in the memorandum of association that the liability of the members is limited to the amount of unpaid amount, if any, on the shares held by them. If it is limited by guarantee, then members, it should be written that what is the amount which members have undertaken to contribute in the event of company being wound off, okay, towards the assets of the company or towards the costs of winding up, or the charges and expenses, how much the members are ready to contribute. That needs to be stated. Okay, that is called as the liability clause. That has to be stated like this. Is it clear to you now?
Yes, sir. Yes. Yes, sir. Yes.
Okay, friends. So thanks a lot. We'll close it here. We'll catch up again in the next class. Thank you very much.
Thank you, sir.
Thank you.
Thank you.
Thank you, sir.
Thank you.
Thank you, sir.